All right, welcome back to the second presentation of Chapter 5 on civil rights. We've been talking about sort of the conditions under which the struggle for civil rights really kind of emerges, and of course the situation with African Americans is sort of replayed in many other different circumstances as other members of minority communities, and of course women who are not a minority find themselves, or are doubly minorities, find themselves again being systematically denied equal consideration and find themselves having to struggle. The Civil War amendments are a consequential moment in civil rights. The election of Abraham Lincoln in 1860 provoked the secession of the 11 southern states. As part of the Union war effort in 1863, Lincoln issued the Emancipation Proclamation, which actually sort of happened after it became clear that the Union was likely to prevail with the victories at Gettysburg and out west. I can't remember the name of the Vicksburg, which were both happened within days of one another. The process for amending the Constitution to end slavery began while the Civil War was still being fought. With the 13th Amendment. The 14th Amendment, again, as I've mentioned, I think multiple times, it is an incredibly consequential revision of the basic architecture of the Constitution. And then, of course, following in 1870, the 15th Amendment guaranteed voting rights for African American men. So, within, again, a 4 or 5 year period, you get three very significant amendments. The only other period where you really have this kind of constitutional revision activity is the Progressive Era, where between 1913 and 1920 you get 4 constitutional amendments in rapid succession. So once you get through the Civil War, once the Union prevails and the idea of secession has been fundamentally defeated, the period of Reconstruction saw initially dramatic expansions of black voting and representation in the states of the former Confederacy. However, by the end of Reconstruction, it's very clear that the South was not reconstructed and that they were determined to find ways of suppressing their black populations through Jim Crow laws and black codes and violence. And then in a series of Supreme Court decisions culminating in Plessy versus Ferguson, the Supreme Court upheld what was a clear segregation law under the separate but equal standard, which again becomes Supreme Court precedent for half a century. Organizing against racial violence, this really, the period from 1877 to 1950, you had over 4,000 black men, women, and children lynched. Lynching refers to the extrajudicial killing, usually by mobs of mostly men, and usually involving hanging, although hanging was not always the immediate cause of death. In this period, white mobs routinely posed proudly for pictures surrounding the lynched victims. Fewer than 1% of white perpetrators of those killings were ever successfully prosecuted for any crimes, much less murder. So in the immediate aftermath of a race riot in Springfield, Illinois, the National Association for the Advancement of Colored People, the NAACP, was formed in 1909 to devise both insider and outsider strategies for battling the escalating violence against black Americans. A founding member of the NAACP, W.E.B. Du Bois, was the first black American to earn a doctorate, and argued that it was critical for the NAACP to use the power of the press to sway public opinion. The NAACP was successful in publicizing the brutality of segregation and racism in the United States. By the 1920s, lynching began to decline, largely again as a result of the NAACP's efforts, and to raise awareness and to appeal to the collective conscience of Americans who were not racist. I mean, those Americans who did not embrace the kind of racism that was prevalent in the South. And there were plenty of racists in the North as well. There were other people who were not. The fight for education equality, again, part of the Jim Crow segregation policies in the southern states included the separate but equal schools and school districts for black and white children. Southern states systematically underinvested in black schools. Teachers were poorly paid. School buildings often lacked adequate resources like electricity, running water, bathrooms, and so forth. The NAACP's Legal Defense Fund initially litigated for access in higher education, and they enjoyed some success in arguing that the separate but equal rule required that black students also have access to professional credentials like medical degree, law degrees, education degrees, things like that, required for black communities to be adequately serviced. One such case involved Oklahoma, McLaurin versus Oklahoma in 1950. George McLaurin, who had already earned a master's degree in education from the University of Kansas, applied for admission to the University of Oklahoma's doctoral program in education and challenged the University of Oklahoma's segregationist policies. He based his argument on the 14th Amendment and on the fact that Oklahoma had not met its burden by providing separate facilities. And the university admitted him but compelled him to sit at a desk outside the classroom, as well as requiring him to sit at a special table in the cafeteria and a special desk in the library. McLaurin challenged those conditions, but lost at the circuit court level, but appealed to the Supreme Court, which reversed the circuit court's decision and ruled that the public institution of higher education could not provide different treatment to a student solely based on the race of the student. So in elementary and primary education, groups of parents, black parents, challenged the state and local ordinances mandating separate schools. And that ultimately would become the case that became Brown versus Board of Education. The court's 9-0 decision was one of the most consequential decisions in American civil rights law. Of course, again, unfortunately, controversy over, access to education continues to this day. Resistance to Brown. The Brown decision sparked massive resistance in states where discrimination was a deeply embedded norm. It may have signaled the end to de jure or legally enforced discrimination. There remained extensive de facto, otherwise discrimination in fact, as a persistent factor. Numerous Southern politicians won elections advocating resistance to the federal government. Among them was Arkansas Governor Orville Faubus, who resisted integration of Little Rock High School, and Alabama Governor George Wallace, who campaigned for office, promising to stand at the courthouse door to prevent the racial integration of the University of Alabama. The concluding line of his campaign speeches was, "I draw the line in the dust and toss the gauntlet before the feet of tyranny. I say segregation now, segregation tomorrow, segregation forever." That's, and he was winning elections that way. So if it rings any bells today, don't be surprised. The civil rights movement after Brown, 10 years after Brown, still fewer than 1% of children in Deep South schools were attending schools, integrated schools with white children. Recognizing the fading commitment of white Americans, a new group called the Southern Christian Leadership Conference adopted a series of campaigns of peaceful, nonviolent confrontation, beginning with a Montgomery bus boycott that was led by Martin Luther King, that ultimately led to him winning the Nobel Peace Prize, followed by the March on Washington for Jobs and Freedom in 1963, where he delivered his famous "I Have a Dream" speech. And then the Selma to Montgomery marches in 1965, where, again, in the first march, you had horrible beatings and violence by highway patrol people. I'm trying to think if there's anything else in this that... Yeah, I'm just going to go on. The Civil Rights Acts, again, what the 1960s was a period of monumental change. The success of the civil rights movement in the 1950s in Brown versus Board of Education and in the civil rights, the Southern Christian Leadership Conference's movements led to passage of two very consequential laws, the Civil Rights Act of 1964 and the Voting Rights Act of 1965. The Civil Rights Act relies on Congress's authority under Article 1's Commerce Clause to ban segregation in public spaces and prohibited discrimination based on race, gender, religion, sex, and national origin. The law empowered what was then known as the Equal Employment Opportunity Commission within the Department of Justice. It created that department to sue private businesses that engaged in discrimination. Title IV of the Civil Rights Act also banned segregation in public education, empowering executive branch agencies to aid the courts in implementing laws to combat ongoing discrimination in education. The Civil Rights Act authorized the president to act through the Department of Justice's Office for Civil Rights to withhold federal education grants to districts that engaged in discrimination. And one thing you learn about federalism is the states and the local areas became very increasingly dependent on federal dollars. So the Voting Rights Act is similarly very consequential. It banned the use of literacy tests and other tests as a condition for voting. It set criminal penalties for interference with the right to vote, and it provided for the replacement of local registrars with federally appointed ones in counties designated by the Attorney General as significantly resistant to registering eligible black voters. The Civil Rights Act's Title VII outlawed job discrimination by all private and public employers. And then in 1968, you also saw the Fair Housing Act that barred discrimination in housing. That was something that actually got Donald Trump and his father in trouble during the 1970s, and they ultimately had to settle the case. And then, of course, you get the famous Supreme Court decision in Loving v. Virginia that was made into a movie that ruled that state laws prohibiting miscegenation or interracial marriage were unconstitutional. So that's it for this slide. When we come back, we will take up the cause of civil rights in the United States. I'll see you next time.